Welcome again to the Melling Law YouTube channel. Today we're going to talk about the rights of surviving spouses in probate. Now before I begin, I just want to say this subject is really important, especially for anybody who is in a blended family situation. So if you have kids from a prior relationship and now you're either married or thinking about getting remarried, these rights are really important for you to know. For one, to know what are your rights if your spouse dies. Can they totally disinherit you? But two, it's important to know by remarrying, what are you what kind of rights are your kids giving up to your estate? Are your kids going to lose out on any part of your estate? And is there anything you can do to change that before you're married or after the marriage has taken place? Now, if there's no will in place, we call that intestacy. So if you pass away, you have no will in place, 100% of your estate is going to go to your spouse. Now, if you have children from a previous relationship, then only the first $75,000 of the estate plus half of any remaining part of the estate will go to the surviving spouse. Everything else goes to the kids or grandkids from previous relationships. And estate, for these purposes, that includes things that normally wouldn't fall under probate. So that's like your uh, pay on death accounts, retirement accounts, joint accounts. These, if there's no will, the spouse is entitled to that 50% as a minimum. Um, but things like insurance payments to that spouse, advances, say you transfer $100,000 to that spouse before your death, that counts toward their minimum. But that way, if there's no will, they do get half of your estate. Now, if there was a will that you wrote before your marriage took place, it's treated the same as the intestacy if your spouse wants to do it that way. So if your spouse remains silent for a certain period after your death, then that's fine. That will be probated as you want. But if your spouse wants to, they have every right to basically nullify that will as it applies to them. So it's the same as that intestate share situation where your spouse is going to get half to all of your estate. There are quite a few exceptions in blended family situations if you've got children from a previous relationship. And sometimes if your will is drafted properly, it might foreclose that surviving spouse's option to negate the will in this specific circumstance. But as we'll see in a minute, even a properly drafted will isn't immune to all surviving spouses' claims. Now, there's this thing called a spousal elective share. This kind of originated out of England centuries ago as a way to provide for surviving wives who weren't allowed to really own property. Nowadays, we've kind of adapted this to keep people from disinheriting a spouse of several decades right before death, and leaving that spouse impoverished. So the elective share basically takes your entire augmented estate, so that's any pay on death accounts, insurance, trust accounts, retirement accounts, any joint accounts, anything that you've transferred within a couple years of your death, even just so if you've given gifts to kids, all of that is taken and considered. It's kind of a complex formula, but basically the court says, okay, all of this, we're going to count up the value. 1/3 of that is the spouse's entitled minimum. So if your will kind of cuts out your spouse or doesn't provide for your spouse in the way that the spouse is entitled, which is 1/3 of the estate, then the court's going to say, we're going to negate parts of this will to make sure that your spouse gets 1/3 of that estate. Now, there's kind of a marital property component to that in Utah, so premarital property is kind of taken out of that. So if it was a recent marriage, a lot of the time this doesn't come in as much, but any kind of commingled accounts, any kind of jointly owned property is pretty much going to be subject to this, and then a lot of other things will be too. This component has a lot of exceptions, and this is something you really want to talk to an attorney about to understand whether your estate is truly going to be effective if something happens to you, because you don't want to leave your kids cut out of whatever inheritance that they're entitled to if that's your goal. Now, a couple other things with this elective share. Your spouse can waive that elective share at any point, even after your death, as part of the probate process. But a lot of times, those waivers can be unenforceable, and it's really, the law's kind of nuanced on that. But the best way to avoid this elective share issue is a prenuptial agreement. So if you are thinking about getting married and you have kids from a previous relationship, and you really want to make sure that your kids or your grandkids get all of your estate, and that you're not going to be, your spouse isn't going to have any claim to your property, especially if your spouse becomes incapacitated later on, and they're going to be under some kind of conservatorship where that person might be duty bound to elect against your will and take a third of your estate. Especially we're talking pretty much anyone in a blended family situation, or even those who are above about age 60 and looking to get married later in life. You really need a prenuptial agreement in place to make sure that this elective share isn't going to be an issue in your estate plan, and that there are no variables. In your will, you can still provide for that spouse, but the elective share isn't going to be an issue that's going to incur costs later down the road for your estate. And finally, as part of probate, spouses and even dependent children, there are several different types of allowances and exemptions available to them. A lot of times, especially for maybe wealthier families that have a higher budget, just to keep up with mortgage payments and car payments and maybe the boat payment and things like that, there are some of the allowances and exemptions might not be enough to cover those costs during the probate process, which can take several months. But so you'll want to provide for that in different ways, and not rely on the court system to do that for them. But some of these exemptions are allowed to provide creditor protection. Those protections are pretty minimal in Utah. So once again, you're going to want to figure out how to provide for them. And then again, that financial support during probate, you really, the Utah protections simply do not provide for families the way they should. And so you're really going to want to plan ahead and make sure that your family is going to be provided for during probate, if you even want to do probate, because there are several ways around that. And that's all for today. Once again, if you are in a blended family situation especially, or thinking about getting married for the second time and you have kids from a previous relationship, you really need to get your estate plan together. You really need to get a prenuptial agreement, if possible, before the marriage. If not, there are other things that you can work on. But please, if you're in that situation, talk to an attorney, because these spousal rights are very nuanced, and it throws a lot of variables into your estate plan that incur extra costs in probate. So you really want to take care of your kids and make sure that your plan is actually going to be effective when it counts. So if you have questions for us, you can call us at 435-572-0807 or at office@mellinglaw.com.